Thanks very much. Can you hear me all right? I'm going to make a few introductory remarks because I'm coming at this from the perspective of civil society. Statewatch has been going now for 26 years, and our job is to monitor civil liberties in the state in the European Union. So I want to look at it from that perspective. I always remember Tony Blair saying when he was in power in relation to surveillance, if it's technologically possible, why shouldn't we do it? And I think there is that question which I think we could put to the panellists. Is it possible to balance security and privacy in real terms? Because our experience is that 95% of the time it's security that comes out when there are debates in terms of what measures are adopted. First of all, I want to take you back to 1697. Does anybody know what happened in 1697? Probably not. That was when the Royal Mail Act was passed. And that was when the monarchy took over the control of the post in order to defeat the evils and ill-doings of the enemies of the Commonwealth. It actually meant the empire, of course, at that time. And ever since that time, or around about that time, every new state that came along had internal and external enemies. And in terms of security, and in terms of surveillance, and in terms of control. I'm always remembering, what does remote access mean? It's been referred to, it's been called hacking sometimes, and I think incorrectly. It is correctly hacking, but hacking has the meaning of people who are private enterprise people hacking, or maybe states hacking. What the EU has been doing for police forces in the EU and security services for years, in most cases until recently without any authorization, have been using remote access. That means the ability to enter anybody's computer anywhere, to look at what's being said, whether they're a lawyer, a journalist, a writer, or whatever, look at it, put things on that computer, and if necessary, alter them. And if you wonder whether that is far-fetched, when I was at a Guardian seminar during the ongoing Snowden affair, Luke Harding, who wrote the Guardian book, The Snowden File, was writing his book. And then he discovered, when he was 6 months into it, that bits of his book were being changed on his Guardian computer. And he had to reread the whole thing twice to put back what he originally intended. It was being changed as he was writing it. And I'm minded to think of Philip Agee. Remember, Philip Agee was somebody who left the CIA and wrote the CIA diary in 1977. It came out with Penguin in this country, was translated into 26 languages. And when he was writing his book, and this is in the days of the old-fashioned plonky typewriter, the days of Tipex and carbon paper, his typewriter broke down when he was in France, and a friend lent him it. And after 3 weeks, he discovered, even in a mechanical sense, everything he was typing was being transcribed to the French security services. So even before computer spying, you actually had another kind of spying going on. And I think there's a classic case at the moment. I think it's a question of dilemma for democracy, whether it's here or in the European Union. And that is in terms of what the issue which has been discussed a bit today, in terms of data retention. In 2014, the European Court of Justice declared the Data Retention Directive of 2006, under a UK Presidency Council, was unlawful. It was unlawful from the day it was passed in 2006. That was in 2014 that judgment came out. In 2016 we had a further judgment on the same issues in the Watson-Davis case, which was basically saying, amongst other things, that the court was concerned that these exceptional, not proportionate powers in their terms couldn't be applied to all crime. It had to be applied just strictly to terrorism and serious crime. It also said that data held in the EU could not be passed outside of the EU, which would completely undermine the EU-USA umbrella agreement. So it meant that member states who adopted various laws have been acting unlawfully since 2006. They knew about it in 2014. I've seen the Council documents where they're desperately trying to work out what to do. They have no idea what to do still. And you ask yourself in other instances, what should be happening if the court says that the actions of member states in their current law and their practices is unlawful? You would expect the Commission to take action against those countries. There's some hope of that happening in terms of the way the EU works. It's never going to happen. And it's true in this country. We've got a new law which legitimises remote access. But it doesn't legitimise it in terms of the European law and how it should be working in terms of the court judgments. I want to end up with one other story, which is, it's a story when I read a book, and I was in Rhodes, in fact, and I took a book off the shelves, and it was written pre-Snowden. And a book in which you had a cashless society. And it wasn't just a cashless society, your card was everything. It was your library card, your ID card, your passport, or your right to health and other services, it was everything. Which sounded a great idea. Except that it developed in the sense that if people transgressed, instead of sending them to prison, you withdrew one of their services. They just couldn't get it. They either couldn't get any money, they had no identity, and in the end you end up with a situation where some people in the book lose their identity completely. Now, of course, this was a liberal book written in the liberal period, and the people rebelled and the system was overthrown. I just wonder today whether people would, if they had the convenience of one card for everything, which would make life simple, what resistance would there be today to that happening? Because it could be argued we're on a path towards it. So maybe the panel might like to comment, and then we can have comments from the audience, but I'm looking at it from a civil society perspective.
Okay, so you're throwing the ball to me?
I'll throw it to you first, yes.
Okay, thank you very much. That's thought-provoking as always, and a tough act to follow, but I will try. I will make 4 points inspired from what you just said on a general and more theoretical perspective, and I'm sure the other speakers will have a lot to comment on the detail. So first of all, I think the first thing that you said, and I think that's probably very relevant to the conversations that we have been having throughout these months and in this project, is the relationship between technology and privacy, and how the technological advances, if you like, can interact with the requirements to safeguard privacy in challenging times. And I think there the big question that, and there we may find ourselves lost in translation in a sense with our friends who are leading on the technology side, because I'm sure those of you who work on technology should be very excited when you discover something new, when you are able to improve the technology to make things, you know, more interconnected and more automatic. But of course, these technological advances pose challenges to private life, and the question there is, do we really, is the way forward really here what we call privacy enhancing technology? So do you try to embed, if you like, the privacy safeguards within what you develop as a platform, or is this really not enough? And I think this is a very big conversation. What we find when courts come to this game very late in the day and react many years after, you know, laws are adopted, we find that the courts are attempting to place limits even on that, because the key question that is not addressed, I think, by privacy enhancing technology is the question of the very collection of personal data. It's not only about the use and the processing where you can have limits, but it's also whether, you know, especially the state should have the power to collect, to access directly or remotely, as you mentioned, personal data for various purposes. And this is an issue that has been unresolved. We have seen in the data retention cases that Tony mentioned that the Court of Justice has come and she said that you cannot really do this in an indiscriminate way. And I think this is even more important in view of the fact that in today's world of data, of big data, of the Internet of Things, of mass surveillance, the boundaries between the public and the private are increasingly being blurred. So the private sector collects, but then the private sector is being co-opted. And I think there we have very big debates about where the limits, where the boundaries should be. The European Commission, as we speak, is developing proposals for legislation which would enable law enforcement authorities to have direct access to databases of private companies, which is very, very controversial from a legal point of view, and it apes, if you like, you know, what the US intelligence services, you know, would like to go around doing. So I think there is a lot of so those of you who are dealing with the technological side of things, be aware that a lot of this may be a breakthrough, but may be problematic in legal terms, and that things are not always as straightforward as they seem. The second point, I think, which I was interested that you mentioned, Tony, is the link between privacy and democracy. And I think that's a very important point. We tend really to view these issues from the point of view of what happens to data, and data can be very fragmented. Data can be pieces of information that may, however, lead to quite a holistic picture of an individual or a profile. And what is interesting, again, from a legal perspective, is that most of the courts that have come to examine obligations of mobile phone companies to retain personal data, the data retention obligations that you touched upon, a lot of courts, not only the European Court of Justice, but also national constitutional courts in Europe, and mostly from countries which either were former communist countries or the German Constitutional Court, all stressed out how problematic this collection, mass collection of personal data is, not only for privacy, but also for democracy. And if you read, for example, what the Romanian or the Bulgarian Constitutional Court have written about this, they have said that you create, by collecting data in an indiscriminate fashion of everybody, without a link with a specific suspicion of something, you create really a suspect society. You create a society whereby individuals are, in principle, suspect. And then they have to prove that they're not elephants. So, you know, so this is a very fundamental, I think, reversal of citizenship in a democratic society. And I think these kind of mass surveillance issues bring this to the fore. The third point that you just mentioned in the end, but I think it's a very important point, is the point of convenience. And a lot of technology is developed by the private sector, but also by the state, and sold in the name of convenience. You know, we have e-passport dates. I mean, it's Njovi's PhD and expertise, and she can say a few words on this. But you know, we have e-passports, you know, for the passengers' convenience. You know, we have all sorts of different databases for the sake of convenience. You do not have to wait as long in the queue. That's not true if you go to Gatwick again back on Sunday. The queue for the e-queue was longer than, you know, the physical checks queue, but that's another story. But it is really a question, I think, for all of us to think about how much of our personal privacy and how much from our, you know, rights as citizens are we giving away in the sake of convenience. And that is, I think, a very big question that I think, again, courts are slowly waking up to. The final point, of course, is the reach. The technology and science is the beauty of being universal. Law, in principle, has the downside of being territorial and sometimes parochial. And we have now all this collection of data, which puts really huge challenges for lawyers, because sometimes we operate on the basis of national law to regulate flows which are global and cross-border. And we see there how limited legislation from a national perspective is. And Tony mentioned the challenges on transatlantic data flows, the challenges that we have for the United Kingdom, which currently has legislation which is not in compliance with EU law on privacy. People ask me what will happen after Brexit. You know, we all hold a crystal ball, and I say that the way the UK law is currently will mean that the UK does not have a system which is equivalent to EU law, which means that after Brexit, the UK companies and law enforcement agencies may not necessarily be given access to data of their EU counterparts because the British law doesn't meet the EU standards. So the big question there is how we move from the national to the cross-border to the global, and whether it is feasible to some extent to have a more global regime to regulate the flows of data, which is non-existent currently. So that's all from now, but we can discuss further.
Does everybody else want to ask? And I think maybe if you want to respond, everybody, that'd be good.
Yeah, I might just touch upon what you said about the card that does everything and solves all the problems. I guess slightly different. One of the ways we've looked at it is that the data that's being collected or that you generate is more and more in the hands of private companies or the state. And as we go through our lives, more and more we're judged by what the data says about us than about what we say about ourselves. So all these little bits of data are all creating what we refer to as like your digital doppelganger. And as you go to try and access credit, or you try and get a mortgage, or you're in court defending yourself, how much are you believed, or how much is your digital self believed and you're disbelieved? And you know, we can all think of instances where the data is wrong, and then how do you challenge that? So I think it may not be, I think there is the issue of convenience, but I think when people hit upon these problems, it's going to be often in the more everyday sense that you question, why are you not being trusted? And why is this data that's been taken from all these different sources to create a sort of a version of you that may not be accurate, and that is very difficult to challenge. I think that's maybe where we may see more resistance on the more practical level, rather than the level perhaps we'd like to see us at more immediately.
I was struck by what Tony said a moment ago, that 95% of the time security trumps privacy. And I agree that that feels very wrong. You know, it shouldn't be that security trumps privacy almost all the time. And I remember once when I was defending privacy, I was defending privacy of communication, privacy of email. And somebody said, well, look, I mean, if you get privacy of your email, or if everyone gets privacy of their email, that may mean some people die, because that may mean that there will be a terrorist attack that does not get foiled, and as a result, people die. So the question that the person posed for me was, how many people am I prepared to see die in order that I and others should get privacy of my email? So obviously I was a bit shocked by that question. It is a rather shocking question, that people have to die so I get privacy of my email. But when I thought about it a bit later, I kind of thought of the analogy with driving at speed. So we have a rule in the UK that you can drive up to 30 miles an hour in a built-up area and up to 70 miles an hour on a motorway. Now we know that those rules cause people to die. I mean, 3,600 people die in the UK every year in road traffic accidents. And we know that we could reduce that number if we simply had lower speed limits. But we choose not to as a society. So we are implicitly making the equation that somehow, you know, the economic benefits of driving imply that 3,600 people will die per year on our roads. Now, when you put it like that, it sounds absurd, but that is what we are doing as a society. And we make these calculations all the time. You know, when we decide how much shall be spent on cancer treatment. We don't have an infinite budget. And of course, it's hotly disputed all the time how much we should spend. But as a society, we end up choosing a certain amount, whatever that is. And the sad consequence is that people die as a result. So I give those stories because I think it's wrong that 95% of the time security trumps privacy. I think privacy should trump security more often. And I think that that will mean that there will be some bad things from a security point of view. And I think we just have to accept that, because that's the price that, as a society, we want to pay in order to have our privacy. So that may seem to go a bit against what I was saying this morning in my talk, because this morning I kind of said, you know, we do have to balance these things. I do believe that we have to balance them. I just believe that 95% is not the right place. Perhaps it's more like 50-50. I don't know. Of course, it's hard to give a number because it's hard to quantify those things. So I want to just make one more point before I release the floor, and that is about mass surveillance and targeted surveillance. So I think most people think that mass surveillance is wrong and targeted surveillance is something that we're willing to accept. And I also sort of think that, but the more I think about this distinction between mass surveillance and targeted surveillance, the more difficult I find it to make the distinction. And I remember when I was discussing the Investigatory Powers Act with somebody a while ago, I said, well, you know, what I don't like about it is that it legalizes mass surveillance. I'm against mass surveillance. And the response was, no, it doesn't legalize mass surveillance because the data is being collected, but nobody is reading it. So as far as this person was concerned, you know, it's the moment at which a human reads the data that it becomes surveillance. Now, to me, that's absurd because, in fact, I wouldn't mind if a human read my data, because humans are so limited in their ability to process data and recall data that, I think that would be okay for a human to read it. What I fear is algorithms reading it, because I know algorithms are much less limited than humans are in their capacity to process data. So that's why in my kind of talk this morning, I kind of ended up with this idea that I'm willing to allow data to be collected, provided it's held in an encrypted form, and then the decryption is the kind of moment at which it becomes surveillance. So that's my kind of personal way of reasoning through what I regard as this tangled issue of what counts as mass surveillance and what counts as targeted surveillance. It's got nothing to do with whether it's a human or a computer. Computers are far more fearful than humans. But it's got to do with the point at which the data would become usable. And that's why in my kind of story about it, I'm putting it at the point of decryption. That's the point at which I want the transparency and the accountability, because it seems to me that that's when the data becomes possible to use for surveillance.
It's a really tough act to follow now after 4 great panelists giving their views on various important topics. But let me start with what Mark just said about computer making the decision and everything. That even scares me, because when they go wrong, it's potentially a massive issue, and it's not easy to spot. There is unlike human, there's probably a bit more logic to deal with unexpected situation. So if the computer, well, the algorithm or whatever is wrong, it would be potentially dangerous. Another thing that Tony mentioned as the last point about the convergence of various cards into one. I see the mobile phone as one of those technology that actually does that. If you want to fly these days, you just have your boarding pass on your phone. You can just pay with that. You do your camera, it says everything. So it does offer convenience by keeping everything in one device that rules them all, in a sense. So I see that as a benefit in terms of practical reasons, but of course the risk of your device being compromised, then a lot of things do fall to pieces. The last point I want to mention is that we would like to be able to achieve privacy. It's an ideal world. It would be straightforward, but as the technology currently is available, it's not always straightforward for everyday users to actually do that. Some of the techniques might be a bit harder to follow. I know there's been a lot of effort to actually make that easier, and the fact that, you know, privacy by design, it will allow the solutions to be built ground up from privacy concern, should hopefully make it easier. But there is still the kind of obstacle to actually achieve that. That's just what I feel.
Thanks very much. I'm just going to make a couple of remarks. I picked up on your point about the mobile phone being the equivalent potentially to a card. And how many people in this room do not have a mobile phone?
Wow.
Now I want to also make a point about function creep, because this whole thing about where do you draw the line in terms of like terrorism, serious crime and crime, is that particularly after 11th September 2001, all of us could understand looking at terrorism. We can understand that. The trouble is it then crept into serious crime, which is fine as it seems, although they lowered the threshold from 5 years to 3 years across Europe. And then of course it became terrorism, serious crime and crime. However minor. No limits to that. And this was that function sheet we've seen over the last 10, 15 years. Measure after measure. And if you look at the EU-US agreement, for example, that does cover, it doesn't even define it, it just covers crime. It doesn't even distinguish. And remember, and it covers administrative crime in the United States. And because it's all been decided now that national law is predominant under this agreement, we must wonder why, for further processing, there are over 2,500 other agents in the United States for whom that data can be passed to. Anyway, there's some thoughts. Perhaps you would like to ask some questions of the panel. Anybody? Or make some comments.
Just while people are thinking about that, I thought I'd just add, I think under the Investigatory Powers Act, it's not just terrorism, serious crime and crime, but also economic well-being of the country.
Absolutely.
So that's a further dilution of the threshold.
Well, it's just a question. I have no idea either way. So do you think it's a wrong approach to mass surveillance and mass collection of data to say, okay, mass surveillance, maybe it's the tide we cannot protect against, but should we get engaged into what data, what algorithm they're going to be using, or what are they going to be looking at? Is it a wrong path or wrong discourse to take up?
Others may have, this is obviously a technical question, a political question. It's what they call bulk collection, and that's what the courts are concerned about. What the courts are saying in the Court of Justice, they're saying is, you may have bulk collection, but you can only be applied, well, this bulk collection is a problem in itself, but then if it is, and what you use it for, it should only be applied to terrorism and serious crime. So it starts to set a limit on it. I want to remind of the needle in the haystack. There is this problem that if you don't start to target, in fact, you've got this problem. The bigger and bigger haystack you're looking at, the harder it is to find it. And so I think there is a dilemma there. But I think, but they're basically, they don't like bulk. They're saying they can only be bulk collected for a very specific purpose and very limited purpose. And only then can it be necessity and proportionality. Would I be right in saying that? I think that's what the court is saying. So yeah, I mean, in other words, something it can have a purpose, but it's got to have a purpose which is limited to specific crimes. There's going to be a necessity for it and a proportionality to it, which is where you define it as only referring to certain crimes. And it's also then saying don't pass the same information outside the country. On that point, I would say, I remember years ago when the Europol was trying to get its agreements with what was then third countries, and they produced an agreement with Norway. And I sent it to my friend Thomas Matisse in Hillsborough University, and said to him, what do you reckon of this, Thomas? And he said, well, Tony, it's a very good description of what the law is. He said, but it's useless in terms of the practice. There's nothing to do with all the court judgments and everything else. And of course, when the EU looks at the adequacy agreements which it can reach for giving information outside the EU, it is basing it on what the theory is in terms of the law.
But in Schrems, the court changed this. It said that you shouldn't only look at the law in a third country.
Right.
You should look at effective protection on the ground, and I think that's why it's an important judgment.
Yes.
You know? So it said that although the law in America is X,
Well,
for example, we know in practice
there's a big problem with the United States. There isn't. I mean, we haven't got the same rights. The Judicial Redress Act is not going to work any better than the Privacy Act does for United States citizens. And the further processing thing, and it also means in that agreement they can pass that information to anybody else in the world without referring back to us. So you could find information on you going into the United States, going out of the United States, coming back in again, and then coming into the UK. And some of your points you were making, you might have a different identity by the time we've gone all around these routes.
I guess one of the important things to remember, and it might pick up on what Mark Ryan was saying about the balance between privacy and security, is we don't have an honest debate about what is the risk, what these powers are really used for. And every time there's a horrific incident, we get told that there can't be any dark spaces, that there has to be backdoors. There is so much more information that exists now than ever did before. What they aren't telling you about is that they can get, maybe they can't necessarily get the content that easily, but they can get the metadata. And it sort of reminds me, I used to work in asylum, is that there's just never an honest debate about immigration and asylum, and the same thing seems to be the case in terms of privacy and security. We don't have an honest debate. About the furthest we've got, which I mentioned earlier as the examples at least in the UK context, David Anderson's bulk report, that just says these powers are useful. You know, we need to know more what the capabilities are and what they help us do without obviously compromising an investigation or the activities by the intelligence services. But I think, you know, when we're constantly told there's dark spaces, we don't know anything, it's just so dishonest. And so that, I think that's one of the problems. You know, you say mass surveillance unstoppable. I think we need to keep asking why. Why do you need all of this? What are these powers being used for? And throughout the IPA debates, we got told we can't tell you, it's too sensitive. Then in our litigation, we got more information. And the same thing happens throughout our litigation. Although we often lose our cases, we get a lot in disclosure that at the very beginning of the case, they said, of course you can't have anything to do with this. It's highly sensitive, you'll compromise everything. And then we get it and we're like, this is it. Not what you made it out to be. And then, you know, then you get transcripts of things that happen in closed proceedings, and it's just, it's constantly pushing. And I think not only do we need the legal challenge on that, we also need the technical challenge on it, because the great thing about Privacy International is we have lawyers and technologists, and I think we need both to really challenge the reality, because, you know, sometimes you're arguing things in the courts and you just think there's no way this reflects what's really happening. But this just is the route we've been taken down, and so you kind of need both. And I think we need, you know, all different communities to be constantly questioning why, if we are going to say mass surveillance isn't the answer, because otherwise we'll constantly be told, well, it's what we need to protect it.
Can I follow up on that? I mean, I very much agree with you that we need an honest debate. And of course, those debates are actually very difficult to have, because as they are in these other areas that I mentioned, like, for example, how much should you spend as a society on cancer? Anyone who dares raise their hand and says, well, I think the limit should be here, is going to be trumped by somebody who says, do you realize you're killing that man because he's not going to get those drugs because of your limit? And that kind of discussion is what makes the debate, the honest debate that you're promoting, very difficult to have. So I wondered if you have any solution to that, or if you have a way in which we could encourage society to try to discuss these issues in a more honest way. And I also wonder whether you accept my analogy there between kind of email encryption and terrorists managing to get plots, and these other two things that I mentioned, namely the amount you spend on cancer and the speed at which you allow cars to travel. You know, because in both of those cases, there's that idea that where you're going to put an arbitrary limit, and then some people are going to die as a result of your limit. So do you sort of accept that analogy, or would you say, actually, no, we can do this in a way in which nobody has to die? I don't know what you said.
Yeah, I mean, I think that's right. I think it's really difficult, but I think we haven't even had those difficult discussions yet. And I think, I mean, whilst I wouldn't want to have a to and fro about you should spend X, you should spend Y, and just, you know, I think a really difficult conversation is what we need to make people really value the data that they're generating, the data that is about them, because I think it's through those really controversial discussions that people will really question, why is all this going there? And then someone, you know, and it's creating those discussions that happen, you know, in the pub or wherever you have them at home, where you do disagree, but through that you try and find a solution. And those haven't even happened in Parliament. You know, everyone's too scared because they don't want to be blamed for the ones who stopped access of the intelligence agencies to getting the data they needed, you know, to stop a terrorist threat. And so I don't think there's ever going to be an easy answer that, yes, that's the limit we should set. It should be X amount of money, it should be there. I think there's always going to be a to and fro, but I don't think we're even seeing that to and fro sufficiently, if that's a bit of a vague answer. But I would rather there were controversial discussions to the kind of very opaque situation we're in now. You know, I'd rather people criticised Privacy International for taking a position on this, in that we say this is our informed position, having been given all the information, whereas our constant responses are now, the definitions you're providing in the Act are opaque. We have no idea what these powers are doing. So we can't even put forward a more controversial position of saying, do you know what we think? Actually, you shouldn't be able to collect that at all. Now we really understand what you're using it for. So, I don't know, perhaps it would be better if there were more controversy.
Exchanging data between EU member states, there is still not a clause in it for someone to be told ultimately that an investigation will be carried out into them. Yes, you've got the right to request information if you think you're under surveillance, but there's no positive right that you have to be informed that you've been investigated. Yes, and to know what that was about. I think the other thing that I was going to mention, that in terms of having some kind of quantitative thing, that even in the United States, and I agree it isn't the security intelligence agency, but in policing terms, state by state, you know the number of warrants issued, you know how many cases resulted from, you know how many were successful. Those are global figures. Why, after all these years, cannot we have that simple bit of information which would tell us that a law is effective or not effective? The same should go in the EU there. We would know if you've got the powers and you think they're important, what did you use them for? What was the result, and what was the percentage of the way you used it, people were acquitted or and in fact, if you think about it, we did a lot of work in the 1990s on stop and search, and we managed to match the boundaries. A good friend in Northern Ireland did it, matched the boundaries with the police forces, and we've got the first figures out showing how, black and ethnic minorities were 10 times more likely to be stopped than white people. And we forced the Home Office to change their statistics. So there can be battles you can fight, but I think to ask for the fact you should know how many have been issued, what for, what kind of crimes they've been issued for, what's the result of them, is surely a simple democratic thing which doesn't endanger state security in any sense.
So exactly that point. My feeling on this is the current approach is shoot first, ask question later. So they feel like there is no such accountability that's clear that you can say that, okay, based on the
law as it is,
we should be able to justify that, okay, this is the actual figures, this is the thing to back up that this is actually correct. But I think there is no such thing at the moment that will allow us to make that informed decision or kind of information to back it up. So my feeling is that at the moment mass surveillance is done without being questioned. Well, and that's got to change, and throwing it back to the power that be, so that they have to justify it. We did it because this was this, and there's a proof. Figures, statistics might change it.
In fact, the same would apply to what was RIPA in terms of the number of requests from the police for information or metadata. I mean, and it's over 700,000 now. Why can't we have a similar kind of figure for that? What is it? They keep putting funny percentages in. You can't work out. You try and read those reports; they're impossible. Why can't we know if you've used it over? It's gone up from 400,000 to 700,000. It may be justified. Tell us what were they used for, what was their effect. They're global figures. They can't hurt anybody, but they're resisting doing that.
Yeah, and the only reports we sort of get are when, say, an organisation like Big Brother Watch, I think they did several freedom of information requests around various RIPA warrants, and it turned out a lot of sort of the local councils were using it for people who weren't clearing up after their dogs and things like that. And these are highly intrusive surveillance powers, and if they're used, that's a totally disproportionate use of those powers. So, we need, I think there's questioning of the initial use anyway, but also, the statistics afterwards, and should we be looking to the companies who are having these powers imposed on them, whether they're technical capability notices, retention powers, to produce transparency reports of some sort that would give us some form of insight, in addition to, say, a commissioner's report or statistics that slowly eke out through FOIA requests or other reports people produce.
Instead they go the other way, because it used to be a fact that when they used to have to issue one certificate for the post and one for the mail, one for the telephone, and then they had to do one for the mail, one for the post, one for the telephone, one for the internet. And now, of course, for several years now, they've collapsed it into one overall warrant, which could also cover a whole organisation. So it might concern an individual, or could cover the TUC headquarters. and they call that one warrant. And of course that means you've got to reinterpret the number of effective warrants historically, because we've got the figures up from 1936, what it would mean they were worth. And of course they've been growing enormously. But again, why can't we know, I can't see why we can't know what these figures are.
Go back to your question, actually, and I think that is, you have many different perspectives. Your question implies, I think, a position that a lot of people take, and I think also some of the panelists here, that it is okay to collect the data as long as you have, some safeguards as to how you use them, either technological ones or legal ones. And I think that's up for debate. I'm personally more skeptical to that. I think that once data is collected, in my view, this is surveillance, and you never know how the data is going to, maybe it's not never going to be used, but it is always there, especially if the retention periods get longer and longer and more authorities have access to that. Then you may have this phenomenon that they're used for other purposes, and so on. So the question is, I think, where is the borderline? And at what stage should the state have access to data which is collected in the course of everyday activities? And that's a very, very big question, because when you're on Facebook, you may not anticipate, if you like, that the government may have access to what you create online, to create a sort of profile. What is also interesting is that, again, courts come delayed thanks to the fantastic efforts of people like Privacy International and other organizations. And they say, the European Court of Justice has said in Digital Rights Ireland, that the argument that everything is fair game because you consent via opening a Facebook account or via signing a contract with your mobile phone company is rubbish. This is not real consent, because otherwise you have no choice. You are outside of the civilized world. There's Tonys with not having a mobile phone, but the rest of us. So the court said this is not real consent. You don't really have a choice, and since you don't have a choice, you shouldn't have bulk collection of data without demonstrating some sort of link to a specific case or some sort of suspicion. So not everybody takes this view. So a lot of people have different views at what stage there should be safeguards. I would answer to your question saying, yes, of course there should be safeguards on the processing, and I agree with you, we should look into that, but only if this does not deflect attention from the bulk collection of data in the first place.
Yeah, I'd like to make one more general point, something we've been working with PI on a bit, which is on the report on interoperability, which has just come out within the EU, and which I've never seen a measure so quickly endorsed by everybody inside, from the Commission to the Council to the Security Commissioner to the Terrorism Commissioner. It was hardly dry on the final report, and they said this is the most fantastic report we've seen for ages. Because what it's proposing is that all existing and future databases in the EU should have a single source search mechanism. Right? In other words, you can search the whole lot by searching one interface. It then says there's got to be a biometric database of all the biometrics covered, and they're including for biometric not just fingerprinting but also facial images as well as iris scans. And then they're saying, on top of that, the final thing we do is a common repository of data, which can include a lot of the alphanumeric data gathered in some of these systems planned to create profiles. So if you imagine that as a totality, I can't think of a better definition of Big Brother in reality, and I've not seen it before, which is the path they're on, but at least we've spotted it while they were constructing, and at least we're trying to expose it now while they're going to have to put everything in place. But it is an extremely dangerous development.
Can I ask a question, please? Does the panel think that the state invasion of privacy and its balance against its use for security is not as bad as private companies' use of private data? Because private companies can do things that the government would find it hard to do. I mean, as a private company, I can kind of, I can partition the data, I can distribute it, I can encrypt it in different ways, I can store it in different places, so that even if you find some of the places, you can't get back the kind of value, right, of the data that I have mined and which sort of invades, people's privacy. I can store it, cross-border. I can lie about what I do with the data. I can say I'm using it for one purpose when I'm really using it for another purpose. It's very hard, right? It's much easier to control and sort of highlight and whistle-blow, the state, but it's very hard to deal with privacy invasion, by companies and to regulate it. I mean, what does the panel think?
I don't know. I think a lot of that sounds like the government, given that they've kept things secret for so long. I think they're both. I mean, at least at Privacy International, we see both state surveillance and what different companies are up to as very serious issues. They both. On the one hand, you have, in many respects, companies being sort of subcontracted as part of the surveillance mechanism. So they're very intertwined in some ways. I think, it will be really interesting how GDPR impacts upon how companies can use data and whether that inspires people to be a bit more aware of the data they're generating, how it's used, how it's shared around, in terms of what data brokers are doing with it. And, you're right in what you say, there's all sorts of things companies are doing. It's kind of difficult. I guess they have different threats. One of the concerns, for example, if you take the police, like if they have the data about you, they can use it and you can lose your liberty. So there are different consequences. But then in the same way, if say your data shared by data brokers with WorldCheck and you can't get a mortgage because of something that a company got wrong, you have different implications on your own personal life. So I think I don't think one trumps the other in terms of where we should pay attention.
I think I agree with you. I think the what is at stake is different. I'm very, very suspicious personally about state surveillance. I think the regulation of the private sector is complicated, but we have a lot of steps been taken over the past 20 years on data protection law, so let's not underestimate this. We have rulings like on the right to be forgotten, for example. We have a lot of steps. And in the private sector, another factor that can change the balance, I think, or the shift, is the role of the consumer. So it may be that being privacy friendly is a selling point for a company. Mm-hmm. I mean, we see it a lot in the United States on the mass surveillance debate and how the different giants are positioning themselves. You see Microsoft, for example, having quite at least publicly a pro-civil liberties perspective, challenging warrants by the US authorities and promising their customers that when they are in Europe, data will be located, let's say in Germany, which has the highest data protection level, across Europe. You have other companies responding in different ways, and I think if you are seen to be too pro-state, it has a reputational damage. So I think don't underestimate this factor about what you expose yourself if you really want to mess up, with people's data, because data security also becomes, if you like, a marketing tool. So I think there are qualitative differences, and there is a difference, but of course increasingly the boundaries are being blurred, and I think this is a very big challenge for all of us looking into that. Where does the private end and the public begin?
I don't think I can advocate one way or the other, but a perception I kind of see from this is there's a slightly different attitude from the consumer or the user's point of view. If it is about the government surveillance, this fear kind of factor is probably a lot higher, whereas in terms of private data companies, users feel like, okay, I get something back from here. For example, they can have their social profile or whatever improved. Of course, I'm not saying it's the right thing to do or not, but some people probably see that as I don't know, acceptable cost for actually getting popular in their circle. So just what I think.
Yeah, I mean, I think there's a certain amount of dubiousness and maybe even hypocrisy with the EU on the encryption question, demanding that they should be able to break encryption in serious crime cases and terrorism cases, when in the knowledge that, given that most of this is going to be handled coming out of the United States, it's never going to happen. And you see that in the secret minutes of the EU-US meetings of Justice of Affairs Ministers. The EU wants to do things, but the United States says, sorry, that our constitution will not let us do it. Or it's a battle we don't want to take on. Yes, so there's a lovely tool when you look at the United States and the United Kingdom. They've got a law saying you mustn't spy on US citizens. We've got a law which says you mustn't spy on British citizens. You never guess what happens.
So there's maybe an increasing concept of not single ownership. This doesn't belong to me. It's like a shared ownership. So maybe I use like a pooled car, right? And then there are lots of additional sort of privacy, issues with that. And I wonder if something doesn't belong to somebody, but it kind of is more associated with a pool of people which could be open and can change. I mean, what are the sort of privacy issues, to do with that? And that, we don't own anything. We just share the use of something. It's really open.
Go for it.
I think it's a big issue, and legally it's fascinating as well. What else can you use instead of privacy or data protection? Can you use, for example, the right to property to approach this? For me, the difficulty, I think the big challenge with the current world and the way in which data is being collected and exchanged and combined, if you like, is that you can have very small bits of information that may be far removed from an individual person, but the collection and combination of all these may give you, as was mentioned by other panelists, may give you a very good picture of an individual. I think that to say that you don't own the data is neither here nor there. I would always look at it from the point of view of the impact of the data processing and collection on the individual in terms of what does this collection of data empower in terms of state control, for example. So, and this is why I think in the litigation so far, and maybe we'll hear more on current litigation, what has been quite useful, I think, for courts and for advocates is not so much the right to data protection, because data protection protects personal data, so pieces of data, but the right to privacy, because the right to privacy addresses the individual as a whole. So, the right to privacy can catch really the impact of the state on private life, on an individual, even when the state has collected bits and pieces of data that you may argue that the individual does not own. So I'm making this too complicated, but in my view, the ownership question is not the most important one, as long as you can show that your private life is affected by the combination of the collection of bits and pieces of data.
I think the sharing of different things is going to come up all over the place. It's hard to sort of guess where. One of the things I've been trying to find examples of is where the Internet of Things, various devices being used as evidence in court. And you can sort of, with any device, you can come up with a scenario where you can question who's generated that data, if it's a sensor, depending on how sophisticated it is. If there's an Amazon Echo in the room and the activation was by accident, but you can't necessarily identify the voice, and it's in a house. One of the other interesting things is increasingly cars are increasingly connected. And if you think about rental cars, all you have to do is get in one now, you turn on the radio, it says connect your phone. There are plenty of examples you can see on YouTube where I think there's someone's house was burgled and the people drove off in his car, and the guys didn't have very good OPSEC and logged in their phone into his radio, and so they left their identity there. You may say in that case like they're stupid and they deserve it, but there are other instances where you could be renting a car and someone's, all their messages are still in that car. So I think there's going to be all sorts of interesting scenarios where we share things and the people who own that or control it, whether it's a company, haven't really thought about the implications of what data they're holding. We heard earlier about also all the different cameras that are in cars. Whether, you know, what if that's a taxi, what if that's, again, a rental car, things like that. So I think, yeah, it's probably, I'm not sure I've got an answer, but I think it's going to come up in all sorts of different scenarios, and maybe throwing consumer protection as well into the debate, perhaps.
I wonder if changing the attitude so that consumer, customer, users, whatever, have ownership will make them more careful about their data, because they feel like there is nothing tangible as, you know, your, I don't know, status updates or whatever. You just do it willy-nilly, easy, done. But if you feel like this is something that owns, associated to you, you own it, but you have to be careful. Someone might misuse this device or whatever. That might be bad for you. If you be more careful about that, then maybe it helps. I don't know. I'm just throwing it out there.
Maybe it's just very hard, right, to end a shared session. It's just very unclear to know when the shared session sort of ends. You know, is it, you know, if it's like a pooled car after you've got out of the car, but maybe they need to keep the data, I don't know, for like insurance purposes, you know, a bit longer. But it's much hard for a personal data. It seems to be easier to manage it, to kind of delete, to remove it. But if it's in some shared usage mode, it's difficult to know when the sort of session ends, and you know when you should manage the data, you know, or do something with it to try and, you know, enhance privacy more.
Maybe that should be made clearer when the user just like turn off the engine. Your shared session's done, so you have to be, you know,
following up actually, the shared nature of data and privacy. Well, sometimes there is inevitable. You know, let's say you go out to a restaurant with your friends, and you're very privacy conscious. You don't upload any photos, but your friends do. So they are entitled to their own data. They upload the photos, which includes you, on Facebook, and Facebook does this magic of just tagging your face without you consenting. And let's say legal issues, and someone just shares their webcam in front of their house, which happens to be your neighbor, etc. Right? My other question was about the businesses becoming more privacy friendly. Isn't there a threat of creating a two-tier system? Let's say, okay, if you want privacy, then you have to pay the price of privacy, and only a few could afford, not the many. Isn't that a threat like that?
I think that's really interesting when we see examples of a lot of the time it seems like it's privacy for the rich, not for the poor. If you look at, for example, compare iPhones to perhaps Android, or when updates happen, if you use a really old phone, you're not going to get them. You're much more vulnerable to, say, to your phone being compromised. And then what's interesting is sometimes you see that various technologies actually really target the rich. So if you look at all the adverts now for connected cars, those are all for really wealthy people. So I think it's both. It depends. I mean, I guess from a campaign organisation, you're perhaps trying to expose both problems. That you know, can you buy privacy, and are you more exposed? But I think, you know, they're really interesting examples. Who does it affect more? Where do you have more control, and where are you more exposed? So I think, you know, I think generally you have less choice if you're you know, if you've got you know, older devices probably. I mean, we only have to look at the NHS. They suffer.
Who gets hacked?
But yeah, I think that's a really good question. I think we need to keep asking that.
Didn't stop another university nearby, but
we are running a bit out of time, so perhaps I suggest if each one of the panelists want to give a final thought, and then we close with that.
Start at this end then.
Oh no, this is harder.
You don't have to say anything. You can say everything has already been said.
That statement. No, I think it's important to pass the control back to the user. There's been a lot of progress towards that, a lot more awareness, for example, and I think we're making the kind of right direction, but it's still work in progress.
My final thought is that we need to kind of work harder to kind of show people what the downside of the privacy invasions are. So during my talk, I mentioned, the novel 1984, and I do personally think that is an important case study in what can happen if you allow security to get out of hand, and you discount privacy. But of course, it's very dated now. Now, other people have written other novels, and some of them have been referred to, and there is, but none of it is very tangible. So, and in fact, often people, far from seeing the downside, they see the upside. So, you get more personalized services if you do your Google searches when you're logged in, and you kind of give more and more data to Google. Well, actually, the upside is that you get better services. And I think it's very hard, even for relative experts like us, to be really in touch with the downside. Tony is the only one who's willing to forego the convenience of a mobile phone. None of us are willing to do that, and that's perhaps because we don't really understand what the downside is. That's my final thought.
A very personal remark about phones, Edmund. When you used to look at carriages on the tube, you used to have people reading newspapers and books. Now 90% are in a world of their own. They're not paying any attention to what's going on the rest of the train. Not even see people who need a seat, they don't get under their seats. I mean, if this is a byproduct of the modern world, then I think that's a bad thing. The good thing, I think, today was that clearly a number of speakers had good ideas about how to increase privacy. And I think the important thing is to work with people in other fields who are working at the political end to get things changed and done, so that there's a link between what people in academia are saying about what could be done for privacy, and working with people at the front end who are trying to get laws changed and balancing laws so they can use your expertise.
Yes, I would also stress the importance of conversations. So I think this field is generating a lot of conversations between the private sector and the public sector, the expertise, and so on. And I think we are very happy. I'm sorry I didn't be with you from the beginning today, but that some of us are lawyers here at Queen Mary. We collaborate with our colleagues at EECS, the Electronic Engineering Computer Science. I think, and we have a number of PhD students working on from a cross-disciplinary perspective, connecting questions from science and technology and the legal questions. And I think the more these conversations exist, the more you will be able actually to address this privacy deficit and to be able to understand what's going on and to generate a debate which is worthy of its name.
I keep hearing from my colleagues who attend various conferences on GDPR that companies are all terrified that they're going to spend more money responding to data subject access requests than to fines. I do not believe for 1 minute that they're going to get that many subject access requests. I wish they would. So I guess my final comment would be, when GDPR does come in, then start sending some subject access requests, because it takes more aware expert communities to dig into that data to understand it. If you send a DSAR to Uber, it comes back, and if you didn't really know what it was, you'd probably chuck it in the bin, because it's very hard to comprehend. But for the people at the university, I would really say, do send some to some companies, think about how to use it, because they're trying to scare everyone, or at least scare the lawmakers that they're going to suddenly be flooded with them. I don't believe they will be, but they should certainly receive a few, I think.